Today, we're jumping into a classic showdown, a homeowner versus their HOA. But this isn't just about overgrown lawns or the wrong color mailbox. Nope. This is a legal fight over thousands of dollars in fees that ends with a really surprising twist, a lesson that being right doesn't always mean you'll win.
In fact, let's just skip to the end right now. This one sentence from the final court order says it all. It is ordered that petitioner's petition is dismissed. That's it. Case closed. So how on earth did we get here?
And that's the big mystery we're unpacking. You have a homeowner, David Samuels, who comes in with a detailed case against what he sees as totally unfair fees. He's got his documents, his ledgers, a whole story. And yet, the case gets completely thrown out. So what went wrong? That's what we're about to find out. Why a case that seemed to have a real point never even got off the ground.
To really get what happened, we've got to follow the money. We need to rewind a bit and see exactly how a pretty small disputed balance just spiraled out of control and turned into this major legal battle.
It really all started with this snowball of fees, and that snowball began rolling because of one single, kind of mysterious number on a ledger.
This number right here, $931.95. This was the seed for the whole conflict. It was just listed as a prior balance from an old management company. The problem? Well, according to the homeowner, nobody, not the new management, not the HOA, could actually show him any paperwork for where this charge came from.
And once that one mysterious balance was on the books, well, it was used to justify everything else. Suddenly, $15 late fees started getting tacked on, over and over. Then came the collections charges for things like demand notices and setup fees. And over 2 years, it all just piled up. By the time they got to the hearing, the HOA was saying the total owed was almost $1,500.
So you ended up with two completely different versions of the story. Mr. Samuel's argument was pretty straightforward. You're hitting me with fees on a balance you can't even prove is real. But the HOA's side was just as simple. Hey, our contract says we can charge fees on a delinquent account. They saw a balance, so they charged the fees. It was that simple to them. Okay, so this all leads to the formal hearing on April 3rd, 2024. This is where both sides get to lay out their case in front of a judge. Arguments were made, sure, but the real story, the thing that decided the whole outcome, was kind of hidden in the technical details.
You can see things moved pretty quickly. The petition gets filed in November, and the HOA immediately fires back with a motion to dismiss in December. After a little delay, the hearing happened in April, and the judge had her final decision ready just 2 weeks later. At the hearing, Mr. Samuels came out swinging. He said, the HOA and/or the collection efforts, if not outright illegal, are at the minimum unethical. You know, he was basically arguing that the very foundation of their claim, that initial balance, was rotten, which made every fee they built on top of it totally unfair.
But then the HOA's lawyer, Ashley Turner, responded with this. Now, I know what you're thinking. That sounds like the most boring legal jargon ever, right? Some technicality. But this wasn't just a technicality. It was the key that was about to unlock and then slam shut the entire case. Because it turns out the fate of this case had nothing to do with those disputed fees. It all came down to two fundamental procedural mistakes. Two fatal errors that were made long before anyone even stepped foot in that hearing. And because of them, the real arguments never even mattered.
The first mistake has to do with this legal idea called standing. So what is it? Well, put simply, it's just the right to bring a lawsuit in the first place. To have standing, you have to be the actual person or, the company that's been directly affected.
And right here is where the first huge problem shows up. Who filed the petition against the HOA? David Y. Samuels, an individual person. But who actually owned the property? According to all the official records, it was a company called Daso Properties, LLC.
And here's the thing that is so crucial. Even if Mr. Samuels owns that LLC, in the eyes of the law, he and his company are two completely separate legal entities. So the wrong party, the individual, instead of the company, sued the HOA. That was fatal error number one.
The second error was just as bad, and it all boiled down to citing the correct law, or what lawyers call a statute. A statute is just a written law. If you want a court to help you, you have to point to the exact rule in the rule book that gives them the power to do something.
And this was the other shoe to drop. The homeowner's petition was based on Arizona's Planned Community Act. Big problem. The property wasn't in a planned community. It was a condominium, and condos are governed by a totally separate law, the Condominium Act. He filed his case using the wrong rule book entirely.
The judge's final decision just connected the dots on both of these errors. She wrote, "The tribunal finds that petitioner as an individual did not have standing. The tribunal further finds that the Arizona revised statute under which this action was brought was improper." So because of those two mistakes, the case basically had no legal ground to stand on. It just collapsed. So what's the big lesson we can take away from this whole cautionary tale? I think it's that in any system with a lot of rules, whether it's the legal system or even just your local HOA, how you play the game is often way more important than why you're playing.
I mean, let's just trace how a case that seems pretty strong can just fall apart. Step 1, you have a real disagreement about money. Step 2, the homeowner decides to file a petition to fight back. But then, Step 3, these critical errors get made in the filing. Wrong party, wrong law. And the result? The case gets dismissed before a judge ever gets to decide if the fees were fair in the first place.
This whole thing really boils down to a few key lessons for anybody in a similar spot. First, all that procedure, it's not just red tape, it's the actual foundation of your case. Second, you have to know who has legal standing. Is it you personally, or is it your company? And third, you have got to verify that you are citing the correct law. The really tough lesson here is that if your procedure is wrong, it doesn't matter how right you are. Your case might never even be heard.
When you really think about it, this case wasn't decided on who was right or wrong about the money. The HOA didn't win because a judge said their fees were justified. They won because they followed the rules of the court, and the homeowner didn't. It's as simple and as brutal as that. And that kind of leaves us with a pretty heavy question to chew on, doesn't it? In a system that's built on such specific rules and procedures, is just being factually right ever really enough?